Welcome to my Zoom. My name is Lindsay Thomas, and I am an attorney with the Ettinger Law Firm. Today, I'm going to be speaking about elder law and estate planning and how you can use that to protect yourself and your family for your future and for theirs. A little bit about myself. This month will be my 10th year with the Ettinger Law Firm. We practice exclusively in elder law and estate planning, so this is our only area of focus. And hopefully, before the end of this afternoon, you'll understand what that actually means. So today I'm going to be focusing on the four reasons our firm prefers trusts over wills. Everybody should have received an email with a PowerPoint presentation. I'm not going to use that today, but it is a good tool. There is also a PDF workbook in there. I'm going to be following along loosely with that, but it is a good thing to look back over if you do have any questions that you want to bring up at the end. At the bottom of your screen, everybody should have a little Q&A box. If you do come up with questions throughout, you can put those in that Q&A box, and I will answer those at the end of the seminar. I will not stop to answer questions throughout that we just will end up getting all over the place. So again, if you have questions throughout, put them in the Q&A box. Some people like to wait until the end of the webinar to ask those questions in case I do answer it throughout. I also received a few emails, a few questions ahead of time that we will also go over at the end. So again, as I mentioned, today we will be discussing the four reasons our firm prefers trust to wills in elder law and estate planning. So first, I'd like to go over a little bit about what elder law and estate planning is, because people don't often know. So when we refer to elder law, we are actually talking about planning for you while you are alive, in case you ever become incompetent, incapacitated, otherwise disabled. We want to have a plan in place for you while you are alive, so the people that you want to handle things can be put into place to do that. Estate planning is actually what a lot of people think of when you're talking about a will. Estate planning is really what documents you have in place for after you have passed away. So again, elder law, we're typically referring to while you're alive, taking care of you. Estate planning, we're typically referring to the documents you have in place for after you have died. The first reason out of the four that our firm actually prefers trusts over wills for estate planning is that wills do not protect you in case you become incompetent or incapacitated. They do not avoid what we call a guardianship proceeding. If you have never put any documents in place and you are no longer competent to handle your own affairs, New York has a plan for you. It is called a guardianship proceeding. This is where the courts get involved and name the person that can be in charge of you as a person and in charge of your finances. The risk of this is, of course, you're not naming this person that you want. And even if they do name a family member, which they often don't because of conflicts, even if they do name a family member, you don't get to decide which family member that is. So that's the reason number one we use trust. When we are creating what's called a revocable living trust, it is a plan for while you are alive and well. It is a plan for your disability. It is also a plan for after you pass away. We're focused on disability now. So basically, when you are creating a trust, you are naming yourself as your own trustee. You have complete control of the assets in the trust. You are also naming a backup trustee, a person who can step in immediately if you are no longer able to handle your own affairs. The benefit of this over a guardianship, well, multiple benefits, but one of the main benefits is that if you regain the ability to handle your own affairs, you can take back control from your backup trustee. Whereas with a guardianship, a court proceeding, you actually have to go to court and prove that you have the ability to handle your own affairs again. Nobody wants to have to go to court to prove that they are well enough to handle their own finances. So that is a big advantage of a trust over a will. Another thing is that you can only, when you have a guardian appointed by the courts, they are only allowed to use the assets for your benefit, which means they can't do additional long-term care planning for you. They have to use those assets for you. When you have done your own estate planning, you can actually put documents in place that can appoint someone who can protect assets in case of a long-term care scenario. One of those documents, which is very important to avoiding a guardianship besides the revocable trust, is what we call a power of attorney. In New York, a power of attorney is for financials only, your finances. A lot of people think they don't need one if they have a spouse because their spouse can handle everything for them. And that's not typically true. Most people have some assets at least that are not joint or beneficiary designated to your spouse. I'm sorry, not joint with your spouse. Your real estate is often joint. Sometimes you have joint bank accounts, sometimes they're not. Sometimes you have joint stocks, bonds, mutual funds. But at the very least, you probably have some assets, IRAs, 401ks, life insurance policies that may name your spouse as a primary beneficiary, but they are not a joint owner, which means if your spouse needs to collect your required minimum distributions or they need to figure out where to send the payments because you're no longer able to do those things for you, they actually have to have a power of attorney to be able to speak to the companies. And actually, it's for the companies to legally be able to speak to your spouse. So even between spouses, a power of attorney is a very important document. Then we often want to go one step further. If you don't have a spouse or you do, they're not well, and then you become incompetent or incapacitated also, you always want to have a backup person in place. New York does not assume that you like your children, so it is always a good idea that if that is who you want to handle your affairs, you have put them on your legal power of attorney. Healthcare decisions, medical decisions, we do what's called a healthcare proxy and living will. The healthcare proxy has the HIPAA language that allows doctors to talk to your agents about your medical treatment. Your living will is more your end of life decisions. My agent knows whether or not I want to be kept alive by extraordinary measures if there is no hope of a meaningful recovery. All of these three documents, your trust, your power of attorney, your healthcare proxy, these are all documents used to keep your family out of court and for you to name the person that you want to handle things if you're no longer able to do so for yourself. Another very important piece of the power of attorney is gifting. If, heaven forbid, you need care in the future, New York allows us to actually save half of the value of your assets, even on the nursing home doorstep, with what we call a gift and loan strategy. If you have money or other assets that you have not protected or are not otherwise protected, and I'll come back to that, and you want those to be protected in case of a long-term care situation. Let's say you have $400,000. New York says we can take approximately 200,000 of that and make a gift to your family members. You still will have another 200. So you started with 4, we gift 200 to your family, you keep another 200. The 200 that you keep is used to pay privately for your care to pay off the gift that we gave to your children. Once the gift is paid off, your children get to keep that money and you get to qualify for help paying for care much sooner than you otherwise would be able to. It is a good tool for protecting assets in case of this care need. If you do not have a power of attorney that allows for gifting, we can't protect any of your money on the nursing home doorstep. So again, really important to have this power of attorney in place. Very good tool to use. The second reason that we prefer trusts over wills is that wills do not avoid probate. A lot of people think, okay, I have a will, I have named my executor, that person can automatically step in to handle my affairs after I have passed away. And that's not actually true. When you name an executor in your will, if any assets pass through your will, your executor actually has to ask for court permission. It's a petition for probate. They have to ask for court permission in order to be able to step in to act as the executor. In doing so, they have to receive what are called waivers and consents from any of your next heirs at law. And New York State says who your next heirs at law are. If you're married and you don't have children, your next heir at law is your spouse. If you're married and have children, it is your spouse and your children. Not married, have children, it's your children. No children, no spouse, it's your parents. So New York basically says who needs to sign those waivers and consents. And they're not something that can be signed prior to your passing. They have to be signed after you pass away, which can often, hold things up in court. Courts like all their I's dotted and T's crossed. So you want to make sure well, your executor has to make sure that all these things are done in order for them to be appointed the executor. In order to avoid this process, we actually use living trusts. When you create a trust, we name your trust as an owner of particular assets, as a beneficiary of particular assets. Then when you pass away, there should not be anything left to go through your will. We want your will to be useless, so nobody has to go through the court process. Your trustee that you have named as a backup to yourself can step in immediately after you pass away. They don't have to ask for court permission. That is a huge benefit, is a huge time saver, and a huge cost saver. A probate proceeding can, when nobody is contesting, when nobody's giving a hard time, can take months at best. If anyone is contesting because they don't like what they're receiving in your will, then it can take years, unfortunately. When you hear someone saying they're in probate court because someone was contesting the will, that can take years. We use trust to avoid that process. Again, your trustee steps in immediately. Also, let's say you own property in more than one state. You own property in New York and you own property in Florida. You can put properties in any U.S. state into your trust, and you avoid what we call a multiple probate problem. Your trust can immediately distribute both of those properties after you pass away. If you only have a will, your executor has to probate in each state where you own real estate. That means that they have to find an attorney that practices in each state where you own real estate, which of course is going to be more time consuming and more expensive. Always when there's more attorneys involved. So again, a trust is a very good tool to avoid that probate process. The third reason that we prefer trusts over wills is actually planning for your children and your grandchildren. When we do trusts, we are often looking at, does it make sense to do for your children what are called inheritance protection trusts? These are trusts that you are creating now while you are alive that protect your children's inheritance from divorces, lawsuits, and creditors. These are also what we call bloodline trusts. If something happens to your child and they have assets left in their trust, so the money that you left to them, they have assets left in those trusts, does not go to their spouses when they pass away if they're married. It goes down to your grandchildren. And if your child doesn't have children of their own, but they have siblings, it would go back to their surviving siblings' trust. If you have an only child who's not married, they don't have children, you can always direct where those assets go. If you want to leave it to another family member, another friend, perhaps a charity, you can direct where those assets go after your child has passed away. These are not restrictive trusts for your children. Your child can be their own trustee. They can use the assets in the trust as they see fit. So you're not saying you don't have access. They have access. unless you choose that they shouldn't. If you have a child who's a spendthrift, someone who shouldn't necessarily come into a large sum of money if something happens to you, you can also name a co-trustee with them. You can name someone else as a trustee for them who can use the money for their benefit. And again, whatever's left in that trust and you pass away goes back to your grandchildren or to your other children if they don't have children. So again, they are known as inheritance protection trusts or bloodline protection trusts. Keep assets in the bloodline. The fourth and probably the biggest reason that people use trusts as opposed to will is for long-term care planning. When we talk about trusts and long-term care planning, we are usually talking about what we call an irrevocable trust. It is also known as a Medicaid asset protection trust. So irrevocable trust and Medicaid asset protection trust in this scenario are the same thing. So don't get them confused. They're not confused. They're not two separate trusts. They are the same trust. So with the irrevocable trust, the purpose of the trust is really twofold. It is both to avoid probate on the assets that you have transferred in the trust. So again, so they don't have to go through the courts, and to start the 5-year clock on any assets that you transfer in. A lot of people may have heard of the 5-year clock, but may not necessarily know what that is. So the 5-year clock is really the government's look back into your life. If you need care in the future and you are asking for help to pay for that care, the government wants to know what you have done in your life for the last 5 years. Have you made gifts? Have you made transfers? And if you have, you may not qualify for help paying for care. The reason this is such a big deal today is because the average cost of care in this area right now is between $15,000 and $20,000 a month. So you can see how your assets could go away pretty quickly if you do need long-term care. So of course, the goal, if you're doing a Medicaid trust or an irrevocable trust, is to start the trust at least 5 years prior to needing care. Of course, nobody knows when or even if they will need care. So it's kind of we're working with the law of averages. We're usually doing Medicaid trusts late 60s, early 70s, unless there's a medical reason to start sooner. So these are all the things that we talk about when we do our first consultation, our first free consultation. Do you have anything that makes it likely that we should need this trust sooner rather than later? So the way the trust works is, unlike a revocable trust where you're your own trustee, you have complete control of the assets, it avoids probate but never protects the assets in case of a long-term care situation. The irrevocable trust avoids probate, starts the 5-year clock, but you can't be your own trustee. So that's really the disadvantage. So revocable, you have complete control, voids probate, never protects. The irrevocable starts the 5-year clock, avoids probate, you can't be your own trustee. So let's say hypothetically, you're naming your son John as your trustee. Even though this trust is called an irrevocable trust, it's not really irrevocable in New York. So be really careful when you're doing research about these types of trusts. If you happen to upon irrevocable trusts in other states, you may not get the right information. In New York, an irrevocable trust can be changed. You've named John as your trustee, and then John does something you don't like, or you ask him to do something and he doesn't do it. He doesn't do something you want. You can remove him as your trustee without his permission, without having to ask for court approval. You are still the boss of the trust, even though it's called an irrevocable trust. You can change who the beneficiaries of the trust are. So today we've got 2 children, John and Jane. We're leaving everything equally to them. We decide in the future, John may need more. He's been helping out more. You can amend the trust to do those things. So again, even though it's called irrevocable, it's not really irrevocable. You also aren't losing control of the assets in the trust. If you put your house in the trust, you still have exclusive use and enjoyment of the property. You keep your capital gains exemption if you sell it. You still keep if you get enhanced star, you keep your enhanced star. So you're not losing any of those things. If you put property into the trust, real estate, and you want to sell it, you can do that. A lot of people think once you put your property into the trust, you can't do anything. That's not true. You can say, "Hey, John, we want to sell the property." He will have to go to the closing. That is one of the disadvantages, but the property can be sold, and now the money goes back into the trust. That does not start your clock over. The money would be protected for the same amount of time as your house, and that money can be used to purchase a new property in the name of the trust. And now your new property has the same amount of protection as your original piece of property. Other assets that you may choose to put into your trust. So again, you've named John as your trustee. So of course you don't want to put your checking and savings accounts in your trust. You don't want to have to go to John to write your checks or pay your bills. So, we're not putting your basic accounts, the money that you need to live off of in the trust. But you might have a CD that you've been letting roll over for years and years. That might be a good asset to put into the trust if you know you're never going to need it to live off of. If you know you're not going to need it, let's protect it. That's a good asset to put into the trust. These are income trusts. If you put a CD into a trust, say $300,000 CD into a trust, that will be producing interest. When a CD comes due with this type of trust, you have to remove any income, interest, and dividends that it produces. So with a CD, it would be interest. If you put stocks into a trust, you can do that. Any dividends that those stocks are producing, you have to take those dividends out. This is not a you can, it is a you must. If you do not, interest, income, and dividends are considered new money to a trust, and new money starts a new 5-year clock for that piece. So we want that money to come out. So you still get any dividends or interest. So that's good. You're still getting the income off of that. Assets that you would never put into a trust besides your basic checking and savings accounts would be retirement accounts, IRAs, 401ks, 403bs, deferred comps, TDAs, TSPs. In New York, these are actually exempted assets. In New York, the principal of a retirement account cannot be looked at as an available resource for your care. For some people, that's huge. For some people, that's where a good chunk of their money is, where their savings is. So the principal of a retirement account is already by law protected. Also, it typically doesn't go through probate because you already have beneficiary designations on those accounts. So by law protected for long-term care, beneficiary designated to avoid probate. Double check that you have beneficiaries first and contingent in case, heaven forbid, something happens to your primary beneficiary. You always want to have a backup plan in place. Another reason we would never move retirement accounts into a trust is actually because it would be considered a taxable transfer. If you remove a retirement account, I'm sorry, if you remove money from a retirement account and put it into a trust, the whole value of what you removed is considered taxable income in the year that you do that. You're not trying to, we're not trying to have you pay higher income taxes. So absolutely, excuse me. You don't need to, you don't want to because of, higher taxes. I'm so sorry. Oh, as we already discussed, the power of attorney comes into play too. So let's say we have created this trust. We put only the house in your trust and you left money outside of the trust. Now, if you need care after 5 years, whatever you put in the trust, your house is by law protected. The lid to the trust shuts. The government knows you have that house, but they can't get their hands into it. But you have this 400,000 outside of the trust that you never put in. It's not retirement money. We can still use the power of attorney to protect the non-trust assets on the nursing home doorstep. So again, all these tools come into play when we are looking to protect in case of a long-term care situation. So real quick to recap before I come back to questions. The four reasons that we prefer trust to wills. First is to avoid a guardianship proceeding. You're putting the person or people in place that you want instead of the courts getting involved to name whomever they want, whoever they think is the person that should be doing that, who cannot use your assets for anything other than your benefit. They cannot protect those assets. Also, to avoid a probate process, remember when you only have a will, there is no trust. If there are assets that are not joint or beneficiary designated after you pass away, the will comes into play and your executor actually has to ask for court permission to be the executor. So we use trust to avoid that probate process. The third reason was those inheritance protection trusts, making sure that the assets that you leave to your children or other beneficiaries are divorce proof, lawsuit proof, and creditor proof, and get where you want them to go. If you have grandchildren, down to your grandchildren. If you don't, back to your other children's trusts. If you only have an only child, to whatever charities you have chosen. Then the fourth and biggest reason is to protect the assets in case of a long-term care situation with what we call a Medicaid Asset Protection Trust or irrevocable trust. Real quick, something that I did fail to mention. Most estates will not have an estate or inheritance tax. That's not to say nobody will, but most of my clients won't. This year, the estate tax limit for New York went up to $7.35 million. If your assets are more than $7.35 million, we should definitely meet to talk about estate tax planning. If you are under that, you will not have any estate or inheritance tax issues. That has nothing to do with retirement accounts that are income tax based. So, these are all things that we can talk about at our first complimentary meeting. A little bit about the way our firm works. We are a flat fee firm. At your first meeting, we will go over what it is that I think you should put into place. Sometimes that's pretty easy to say, like, this is what I recommend. Sometimes this is a back and forth. We need to go over your particular set of circumstances. Your circumstances are not the same as your neighbors. Please don't talk to your neighbor and say, oh, well, they did this, we need to do that. That's usually not the case. So definitely we do the first free consultation. At that meeting, I will go over my recommendation and exactly what the price will be. Again, flat fee, not based off the value of the assets. It's based off the work that we are doing for you. We don't charge for telephone calls or emails. We don't do annual fees. There's no maintenance fees. Everything is upfront. The only time we charge anything additional when we are doing planning is if you do new work. So today you decide, I don't need a trust. Yeah, I want to start with just my will, power of attorney, and healthcare proxy. You're not paying for a trust now if you're not doing a trust now. That would be something additional that you might do in the future. So again, we talk about whether or not it makes sense to do those documents now, or if maybe we hold off and do them in the future. So everybody, everybody's first meeting is going to be a little bit different. At the first meeting, I also give you a copy of our book. I should have one right here. Ettinger Law Firm's Guide to Protecting Your Future. After the first meeting, I'll know probably what my recommendation is, unless you've got a very complicated scenario. But I will know what your recommendation is, and I will give you some specific chapters to read on a sticky note in this book that you can take home, highlight in it, take notes in it, and then use that for your second meeting to come up with additional questions for me. Because a lot of times at the first meeting, people don't know what to ask. And that's okay. We know that it's usually new information to you. So you come back with your questions for this second meeting. If you choose to move forward, we do a proposal for you, a written proposal. It's not a retainer agreement. We do not take payment unless you actually sign documents, which typically isn't until a third meeting. The proposal is just the place where you have it in writing that these are the fees that we have discussed previously. And if you choose to come back and sign the documents, that again is the only time that you would be paying. If you would like to set up a meeting, you can always email us back to the email address that sent those emails out to you, or you can log into, Google trustlaw.com, TRUSTLAW.com, and set up a meeting there, or you can always call our 1-800 number. That is 1-800 500 2525. And again, you can set up your complimentary meeting that way. Um, if anyone does have any additional questions, I don't see anything currently in the Q&A, but if you choose to do so, you can always put them in there. I'm going to go very quickly over the few questions that came in before our meeting today. So the differences and benefits of irrevocable and revocable. So we'll recap that real quickly. A revocable trust, you are your own trustee. You have complete control of the assets in the trust. It avoids probate, but never protects the assets in case of a long-term care situation. The irrevocable trust, or also known as the Medicaid Asset Protection Trust, both avoids probate and starts the 5-year clock on any assets that you transfer in. So after 5 years, whatever has been in the trust for more than 5 years cannot be looked at as an available resource for your care. The disadvantages of that, of course, are that you are not your own trustee and you do not have access to the principal of the assets and the trust, but you are still entitled and required to take any income, interest, and dividends that the trust produces. So some pretty big differences. And of course, I don't know what you or your family need until we do have that first meeting. James. If anyone would like to come in and do a review because you met another attorney somewhere else, you are more than welcome to do that. You would call that same 1-800 number and you can always request a particular attorney. That is not a problem at all. Um, I have a will and trust that I set up through another attorney, but considering changing firms. One question I have, is it better to start from scratch or would your firm work with what we established as a starting place? So that really depends on the documents that you have in place. If it's a revocable trust and now we're looking at long-term care planning, we might need to start from scratch, but I don't actually know that until we review your documents. So we do a complimentary review of other firms' documents. So definitely set up a review with us. We bring them in. I'll look over everything with you and we can decide together if it makes sense to start from scratch or if all we need to do is amend your current documents. But again, I don't know that until I see the documents. So that's a good question and that's a good starting point. Bring those in. We'll look at that together. Estate trust. We can definitely talk about going over, will versus trust for you and your family. I need guidance on wills, trusts, and healthcare proxies. So, we did go over the differences between wills, trusts, healthcare proxies, as I mentioned before. That is for medical decisions only. It has the HIPAA language and the living will. HIPAA language is what allows the doctors to talk to your agents about your treatment. Living will is more the end of life decisions. I do want this, I don't want that, with regard to end of life. Interested in educating myself on different trusts. I will be 65 in March. So you might be at the very beginning of this conversation, but it is never too early to learn about these types of things. If you want to come in and do a complimentary consultation, we may find other factors that make me say that we should do a trust sooner rather than later. So definitely come in for that complimentary review and we can decide whether or not that makes sense to you. I do have one more question in my Q&A now. Can a house and an irrevocable trust be sold and the proceeds be used for living expenses? Kind of yes and kind of no. So technically, once assets go into an irrevocable trust, you don't have access to those assets anymore. But there is a provision in the trust that allows for gifts to be made out of the trust to the beneficiaries of the trust. So there is a legal mechanism to remove monies from the trust. You can't do that personally from an irrevocable trust because you're not your own trustee, and you would absolutely want to work with us on how you can legally do that. So, yes, but you have to do it properly. So always the answer is if you've done an irrevocable trust and you want to do that, call us first and we'll kind of walk you and your family or you and your trustee on how to do that appropriately. Are there any other questions? I'm going to give a couple more seconds if I don't see anything else pop up. I'll let y'all go for the day. Like I mentioned, if you would like to set up a complimentary consultation with myself or anyone else in the firm, the number is 1-800-500-2525. I look forward to speaking with you. I don't have any other questions, so take care, everybody. Have a great day and Happy New Year.